Chris, wrongful dismissal suits. Clients will be getting demand letters left, right, and center, and there's a whole group of lawyers that act for plaintiffs, and a bunch of lawyers act for employers. But with COVID, what's happened with wrongful dismissal cases? Have they increased, decreased? What do you see coming?
Yeah, it's been an extremely busy time for employment lawyers, both for plaintiffs and defendants. There's been a surge of wrongful dismissal allegations arising both from extended periods of layoff and changing workplace conditions, which people are alleging amount to a constructive dismissal, and also from terminations that have had to happen because of reductions in the workforce or from restructuring. So there's been a large increase in the number of wrongful dismissal claims, and I think right now the courts are being flooded with lawsuits that will likely be heard over the next 6 to 12 months. So when we look at a wrongful dismissal case, pre-COVID, there was kind of a standard analysis that we do, and we look at 4 factors when determining what somebody's notice period is in the absence of an enforceable employment contract. And those factors are the employee's age, their length of service, the position that they had, and then the availability of similar comparable employment. One of the questions that we're thinking carefully about as employment lawyers is, what will the impact of COVID be on the notice period? Will employees be entitled to longer notice periods because of COVID, because of the difficult economy? And it's tough to say because the situation is so unprecedented. But if we look to some previous economic downturns, there is case law precedent for the courts taking into account the economy and giving employees a longer notice period, giving them higher severance pay because of the difficult economy in general. So we think it's possible that those cases could be looked at and relied on as precedent by judges today. But on the other side of that coin, the courts may be a little bit more sympathetic to businesses. So Mike, what do you think about that?
Well, again, you've hit it right on the head. If you look at the timing, 1981, there's a case called Hunter Northwood Pulp that our Court of Appeal said, well, economic circumstances can be taken into account to favor a longer notice period, but they can't be given undue weight. And lawyers love that type of talk. All we know is the bottom line. In that case, a 2-year employee, non-managerial, got 8 months notice. So that was pretty big. And so when we had Hydro lay off 100 engineers, that obviously had an impact because the employees couldn't get jobs. I've heard lawyers, very knowledgeable lawyers in this field, talk about it may swing the other way, that this is such a huge change to the way we operate going forward, that just like the government has given a whole bunch of lifelines to businesses, in large part to keep employees safe, we think that the courts may well give the same type of lifelines to employees or to employers to limit the period of notice, and maybe readjust the Hunter case to take into account legitimately the employer's side. We hope so, because that could be devastating if you say a regular employment wrongful dismissal is going to be extended. We should say, and we do an ad for this every time Chris and I get on the chance to do an ad, employers that have a properly drafted, enforceable written contract can limit their liability to a total of 8 weeks severance pay as per the Employment Standards Act. So somebody who's 24, might get 24 months in court, if you've got an enforceable contract, they could be limited to 8 weeks pay. Now that may seem draconian, but that is the law. And so pay us now, pay us later. At some point, coming back and starting up may be a good time to take a look at, is it in everybody's interest to have a written employment agreement? And I think that may take care of some of the cases. Quickly, human rights. There's usually, that's front and center. It's kind of Sleepy Hollow. That doesn't mean that it's gone. There are going to be a number of human rights cases that have been percolating along. We know that. We know they're kind of backed up at Human Rights Tribunal. We think there'll be a lot of cases come out of COVID, stress leave, et cetera. The law here with respect to you can't discriminate on family status is very limited in BC, interestingly enough, because of a case dealing with Campbell River. But there still may be some employees that say, look, I got to take care of my kid. I want to be on a leave, a paid leave, part-time leave. You've got to make all these accommodations. So we're waiting to see how that will come out. So the impact of COVID per se, and people that are just traumatized by all of this. And of course, people going back to school is going to be a big issue. So human rights issues may come up. We found that the one thing out of COVID, instead of having in-person seminars, we're doing more and more webinars. Because we think if employers, and especially the HR managers or the CEOs or whatever, can understand the landscape of a general area without drilling down, they may start to see how they can organize their affairs better to avoid the problem. The thing is, if you go to webinars, you may find a way to avoid phoning us when you've got a real problem. And so we're going to continue to do that because we think coming out of COVID, there will be a lot of activity. So check us out. We'll be putting that on our website and letting you know what's available. Any questions, you give us a call. We'd be pleased to chat with you.